John D. Rockefeller, the richest American in history, lived by one rule: own nothing, control everything. Elon Musk doesn't own his mansion. Jeff Bezos doesn't own his yacht. The Walton family doesn't own Walmart. On paper, they're paupers. In reality, untouchable. This isn't tax evasion. It's not illegal. It's a legal structure called a spendthrift trust. And once you understand how it works, you'll realize why everything you've been told about building wealth is backwards. Most people think wealth is about accumulation. Your name on the house deed, the car title, the bank account. But here's the secret the 1% know. Ownership isn't a trophy. It's a target. If you own it, you can lose it. If you own it, you must pay taxes on it. If you own it, a judge can take it away. There's a difference between being rich and being wealthy. The rich man owns his assets. He's vulnerable. The wealthy man owns nothing. Yet he lives in a mansion, flies private, and cannot be touched by lawsuits or creditors. How? Let me show you with two people. First, John. Successful professional, $5 million in assets, all in his name. House, cars, investments. He feels secure. One day, John gets sued. Car accident, malpractice, bad divorce, doesn't matter. The judge looks at public records, sees $5 million in assets, orders a seizure. Overnight, John is zeroed out. Now, the Baron lives in the same house as John, drives the same car. But if you search public records, the Baron owns nothing. When the Baron gets sued, the judge finds zero assets, nothing to seize. The Baron is judgment-proof. Yet the next day, the Baron is still flying private. How? Because he separated enjoyment from ownership. The tool? An irrevocable spendthrift trust. A spendthrift trust has three roles. First, the grantor. That's you. You transfer your assets, house, stocks, cash into the trust. Legally, you're gifting them to the structure. Second, the trustee. This is the manager. Could be a trusted friend, family member, or private company. They legally own the assets now. They control the checkbook, not you. Third, the beneficiary. That's you again. You get to use the assets, live in the house, receive income, but you don't own the source. Here's where it gets powerful: the spendthrift clause. This clause states that the beneficiary cannot voluntarily or involuntarily sign away their rights to the trust's money. Meaning, even if a judge orders you to pay a creditor, you legally can't. You don't control the checkbook. When a creditor comes, you say, "I'm sorry, I'm just a beneficiary. I have no control. Go talk to the trustee." And the trustee? Legally bound not to pay. Stalemate. Billions protected annually. This isn't theoretical. 2019, California doctor, $12 million malpractice lawsuit. He lost. Plaintiffs tried to collect. His house? Trust. His investments? Trust. His cars? Trust. They collected $200,000 from his personal checking account. Everything else? Untouchable. Another case. Texas business owner. Company collapsed. Owed creditors $8 million. Filed for bankruptcy. His personal assets protected in a spendthrift trust. Creditors got pennies on the dollar because legally he owned nothing worth seizing. Now the big one, the Walton family. They don't own Walmart. Their shares are held in dynastic trusts. When Sam Walton died in 1992, his estate was worth $8.6 billion. Estate tax rate? 55%. Should have owed $4.7 billion. What they actually paid? A fraction. Because the wealth was already in trusts, structured decades earlier. Protection is half the game. Taxes are the other half. If you sell $1 million of stock to buy a house, you pay capital gains tax. 20 to 30% gone instantly. The wealthy don't sell, they borrow. The trust owns the assets. The trust takes a loan against them. Here's the magic. Debt is not income. It's tax-free. So the Baron takes a tax-free loan from his trust assets, lives on that money, pays zero taxes. Legally. When he dies, the trust names the next beneficiary, avoids probate, avoids estate taxes. Generational wealth preserved. This is exactly what the ultra-wealthy have done for over a century. So why don't more people know? Two reasons. First, trusts sound complicated and expensive. Legal fees range from $3,000 to $15,000, depending on complexity. Most people hear trust and think only for billionaires. But here's reality. That one-time cost protects millions for life. For someone with even $500,000 in assets, It's a bargain. But financial advisors don't mention it because they make money managing your assets. If your wealth is locked in a trust, fewer transactions, fewer fees for them. Second, the legal system profits from your vulnerability. Lawsuits, divorce settlements, creditor claims. The entire industry depends on assets being seizable. If everyone used spendthrift trusts, massive portions of the legal economy would collapse. Nobody's incentivized to teach you this. Now, the catches. First, it must be irrevocable. Once assets go in, you can't just pull them out. You're still the beneficiary, you receive distributions, but you don't have direct control. Second, timing matters. If you transfer assets after you're already being sued, or after creditors are coming, courts can void it as fraudulent conveyance. This only works if you set it up before trouble starts. Third, not all states recognize spendthrift protections equally. California, weak. Nevada, Delaware, South Dakota, Alaska, strongest asset protection laws in the country. That's where the wealthy set up trusts. Fourth, this doesn't protect against everything. Federal taxes, child support, alimony, criminal restitution can still pierce the trust. But for civil lawsuits, creditors, divorce, incredibly effective. Here's what bothers me. The legal system has two sets of rules. One for people who own assets in their name, vulnerable to lawsuits, creditors, divorce, taxes. One for people who structure their wealth properly, protected, untouchable, generational. The gap between those two groups? Knowledge. That's it. The Waltons, the Bezos family, the Musks didn't get special laws. They used laws that already exist, laws you have access to right now. But nobody tells you. Your financial advisor doesn't mention it. Your accountant might not know the details. Your lawyer probably specializes in something else. So you go through life accumulating assets in your name. Then one lawsuit, one business failure, one divorce, and it's gone. Meanwhile, people with the same net worth as you, structured properly, untouchable. If you have assets worth protecting, anything over $250,000, here's what you do. Research Nevada asset protection trusts, Alaska trusts, Delaware trusts. Talk to an estate planning attorney who specializes in asset protection, not general law. Ask specifically about spendthrift provisions, fraudulent conveyance protections, and which state law applies. Do it now, before you need it. Because once you're being sued, it's too late. The ultra-wealthy don't wait for disaster. They plan decades ahead. They don't ask, how do I make more money? They ask, how do I keep what I have from being taken? The answer is almost always the same. Don't own anything. Let the trust own it. The system is designed for you to accumulate wealth in your own name, where it's exposed, vulnerable, seizable. But the people who actually stay wealthy, they learned long ago. Ownership is a liability. Protection is a choice. You just have to know it exists. If this made you rethink how you hold your assets, good. Because once you see it, you can't unsee it. The spendthrift trust is just one layer. There are banking loopholes, corporate shells, privacy protocols we haven't uncovered yet. This is just the beginning. Subscribe to unveil more secrets.